Compliance risks, Section 125, like I say, one of the biggest things I've seen in Section 25 is a broker will go out, the employer has a POP plan, they take over the case, selling an HSA as the motivating factor to move to them and how to work an HSA, and they forget to go back and modify the plan document to pre-tax the HSA contributions. Now you got a plan that's out of compliance, that plan is now disqualified because you have no provision in the plan document to authorize the pre-taxing of the HSA contributions. So you've got to take stock of that type of thing. ERISA, again, in the fully insured market, the insurance carriers are concerned with state regulations because that's what regulates them. I have not yet seen a single certificate of coverage that is a qualified summary plan description for ERISA, and as long as you have one common law employee, you have to have a valid summary plan description and a valid plan document, and neither of those are complied with from ERISA standpoint by any plan I have seen from any major carrier yet. They comply with all the state laws, but the one thing that I note that is not in those plans is one of the requirements of ERISA is that you state in the summary plan description and in the plan document either the specific position or the specific individual that is responsible for service of process. And they don't do that. They can't because it's different in different companies, and they can't just blatantly put it in there that it's the president of the company when the company may say it's our financial officer. That's just one thing, and it's like being kind of pregnant. If you're out of compliance, you're out of compliance. Period. And you were familiar, NAHU has a relationship with Plan Doc Builder. You learn it yourself, or you can get it put together for $300 or $400. Some of your third-party administrators offer ERISA compliance documents to put wrap documents around your documents out there. Not a big risk. Why? Because if there's a risk in most areas of ERISA other than a 5500 filing wrong, you've got 30 days to make the correction before any penalties are assessed. So if you have a plan that gets audited or somebody asks for it and your client comes to you, you've got 30 days from the time that the request is made to make the plan changes. HIPAA is of course a big one. Most of us are in a market where it's not as toothy and hostile as it is in the self-funded market. Fully insured, hands-off, you have a very limited liability, but there is liability you need to understand there, and the client needs to understand. Don't have your clients, HR, helping too many people too aggressively on filing, processing claims. Bring that in your own house and handle it properly with regard to HIPAA. Discrimination testing, Section 125 has 3 tests. Health FAs have 2 tests. Dependent care FAs have 4 tests. Section 105H is waiting in the wings right now to have the regulations on it to start applying self-funded discrimination tests to fully insured plans. That will be a real bugaboo if they ever come out with that.